Welcome to the Virtual Spring Meeting 2020, brought to you by the American Bar Association Antitrust Law Section. The Spring Meeting is the section's premier event, a multi-day celebration of learning and camaraderie. The Virtual Spring Meeting brings together the world's leading experts on competition, consumer protection, and privacy law, discussing the most compelling issues of the day. Enjoy the show.
Hello, and welcome to the Virtual Spring Meeting. My name is John Roberti. Today we have a very special panel. It is the agency update with the FTC Bureau Directors. This is the very first of our video casts for Virtual Spring Meeting. So before each of the video casts, I'm going to come on with an expert who's going to try to put the program into a little bit of context. And today we're very, very lucky to have Shylah ALFONSO as our expert. Shylah is the chair of the Antitrust and Unfair Competition Practice at Perkins Coie, and she is also the chair of the Federal Civil Enforcement Committee at the ABA Antitrust Law Section. And the panel today is presented by the Federal Civil Enforcement Committee. Shylah, hi.
Hi, John. Thanks for having me.
Shylah, what's this panel about today?
Well, this panel is always a really important session at the spring meeting because it's a great opportunity to hear from the Bureau directors, what they've been doing in the past year, but probably more importantly, the priorities that they will be focusing on in the coming year.
Great. And what are we hoping to get out of it?
Well, really, again, I think the priorities, what they're focusing on this year. Also, I'm sure a topic of conversation is going to be any impacts from COVID-19, how the agency is dealing with that. Is it business as usual or have things changed? And what are the best ways to kind of approach the agency and deal with that?
Great. All right. Well, shall we throw it down to the panel, Shylah?
Before we do that, I just want to do a quick reminder that before we begin and we kick it over to Jonathan GLEKLEN, who is the moderator, that Andrew Sweeting, Ian Connor, and Andrew Smith each speak for themselves and not for the commission or any individual commissioner. Okay.
Very good. Important reminder. Shylah, will you stick around after the panel? Maybe we can come back and get a few of your takeaways?
Absolutely.
Great. With that, let's send it over to the panel moderator, Jonathan GLEKLEN. Jonathan, take it away.
Thanks, John. We are joined by Andrew Smith, who's the director of the Bureau of the Bureau of Consumer Protection, Ian Connor, the director of the Bureau of Competition, and Andrew Sweeting, the director of the Bureau of Economics, all at the Federal Trade Commission. Gentlemen, thank you so much for joining us in these very trying times. How are things going at the Commission during the coronavirus crisis? Is the business of the Commission getting done? Are the priorities of the Commission changing given the current crisis? Maybe you could tell our listeners and our viewers, are there things that have been put on hold, or are there other initiatives that are being accelerated, or is it really business as normal? I guess I can let any of you chime in whatever order you'd like.
Well, okay, fine. Then I'll start. This is Andrew Smith. I think that it is not business as usual at the FTC. I mean, we're all working from home and and the staff is making really remarkable sacrifices to be as productive as they are. We have, the work of the Bureau of Consumer Protection continues, but COVID scams have to take precedence. And so right now, we are focused particularly on spurious health claims, and we've sent out dozens of warning letters. I can say dozens at this point. And we also are focused on robocalls and have sent out warning letters to providers of VoIP services and also DID services. But we expect that the threats are going to be evolving. Now we're talking about health claims. But soon we'll be talking about charity scams, and we're already getting reports of government check scams with the promise of $1,200 to consumers. And so we're trying to respond to all of those. And as the crisis works its way through the economic system, we anticipate that we're going to soon start seeing scams regarding mortgage relief, as well as abusive collection practices and the like. So the threats to consumers are evolving. We have been responding to them. And the work of BCP, the regular work that we had planned on doing, also continues. I can't think of any initiative that has been paused or stopped as a result of this. I anticipate, though, that as COVID scams demand more and more of our resources and time, that we may have to start setting some priorities. But for right now, particularly our regional offices and our Division of Marketing Practices and Division of Advertising Practices are spending a lot of time, and our Division of Consumer and Business Education, who's been really doing a yeoman's effort to get out blogs and other consumer education materials multiple times a day. That all of them are devoting considerable resources to the COVID response.
Thanks, Andrew. Ian, how about at the Bureau of Competition?
I think it's similar to what Andrew Smith just said. And our staff is working under very, very difficult circumstances. We are all almost exclusively teleworking now. And so the fact that everybody is in different places makes things harder. But I think we have adjusted remarkably fast to what is this new normal. The pre-merger office and their staff has been truly remarkable. They set up an e-filing system over the weekend, shut down for one day, and started having filings the next day. And we've had basically no interruption since that system went into effect, and we've been taking on filings on a regular basis. We actually got comfortable enough with that we announced earlier this week that we would be restoring the early termination process, which we had suspended when we switched to that e-filing system. Overall, I think the Bureau is functioning better than I would have expected, given the circumstances. We all have obligations on our personal time, especially with the shutdown of the schools across the various regions in which the competition mission operates. We still move our cases forward. We still make our recommendations, as evidenced by the complaint that was issued last night. We still will bring challenges against anti-competitive transactions. Actually, during the 3 weeks thus far, we've had one consent to a merger challenge and one merger challenge filed. And that's only in the 3 weeks we've been teleworking. So I think overall we are operating as close to business as usual, but as Andrew said, it is certainly not business as usual.
Thanks. And Andrew Sweeting, how about things at the Bureau of Economics?
So, I mean, our staff have also been doing a fantastic job in terms of adapting to what is a kind of tricky situation for everyone. I think both in terms of kind of research and case missions, things have been moving forward, really, as Ian said, kind of better than one might have expected, given the circumstances. One thing we are trying to do internally is to kind of look ahead and to think about, are there going to be issues, for example, to do with financial distress that we may be kind of looking at, in a few months' time, depending on how the situation evolves, that we can kind of think about now how we would deal with those issues.
Thanks. Recognizing the work challenges that the Commission staff is facing, that you all referred to, and people having to juggle multiple things going on at home, do you have advice for practitioners about things that they should be doing differently in interacting with the staff while we're in the midst of this coronavirus crisis?
So I'll start from the competition side. I think the most important thing is going to be patience and understanding. And we are not as responsive as we were previously, though we're actually still pretty responsive. But asking for people to jump on a call in 10, 15, 20 minutes is difficult right now, especially as we are trying to juggle various other things. The one thing that I've noticed in my calendar, and I think this goes for across the Commission, is the number of phone calls that now we're participating in has exploded. What used to be a 5-minute phone call or a 5-minute conversation in the hallway is now a 30-minute or an hour-long phone call. And so understanding that people people may be working different work hours. So little kids may be responding to things later in the evening or early in the morning. If you need an immediate response, try and copy as many people as possible on various emails so that you're more likely to hit somebody that's there.
Andrew Smith, any advice?
Unlike Ian, so people generally are waiting for Ian's call. And unlike Ian, people are probably delighted not to be hearing from the Bureau of Consumer Protection as a general matter. I would say that we, though, have had some party meetings, over the telephone or over Zoom or the like, and people opposing counsel have been very good about it and very accommodating, and we have tried also to accommodate. And I will say that all of our 5 commissioners have also been very accommodating and flexible. So I guess we ask for flexibility, we ask for consideration, but I think that we are able to, with respect to interacting with outside counsel, we are able to do that almost as effectively as we ever could. We are definitely seeing some opposing counsel or parties where that everybody's under stress, and there are and the client is also under stress, financial stress, and so we are seeing some requests from opposing counsel for flexibility on our end, and we understand that, and we are accommodating that as able. But we do need to continue the work of the Commission, particularly if there are instances where we believe that where there's ongoing injury to consumers.
Thanks. And Andrew Sweeting, what about dealing with economists?
So I think that the main thing we're kind of noticing is that obviously when there can be kind of in-person meetings with either outside economists or with parties, people obviously read the body language a lot and kind of respond and react to that. And because, that interaction is being removed sometimes when everything is being done over just an audio connection, I think the more that we can kind of see the issues that parties are going to be bringing up in advance, and maybe we raise the issues with the parties that we want to discuss, kind of the more productive these meetings become. So I actually think they are going pretty well at the moment, but my guess would be that over time, we kind of learn what works and what doesn't work, and counsel does too, will become even more productive.
Thanks. It seems that for as long as we've all been practicing, there's a recurring refrain, are today's laws and institutions, appropriate or well-equipped to meet the current challenges? And, we've asked that question about, 25 years ago about new technologies and new information technology, or in more recent years asking that question about are today's laws and institutions adequate to deal with big data issues? And I guess they almost seem quaint in comparison to the magnitude of the current situation. But let me ask the question about coronavirus. Are today's laws and institutions adequate to protect consumers and competition in the consumer crisis, in the current crisis?
So I'll start on that. This is Andrew Smith. I would say that certainly our authority to address unfair and deceptive practices is, the listeners probably know, that's very broad authority, and we've been able to adapt that to a wide variety of circumstances, and we're able to do so here too. There's actually an interesting note that we've seen over the last couple of weeks. I talked about how we had been pursuing robocallers, and in fact, we've been taking a new tack where we are pursuing VoIP service providers, which we haven't done in the past. And what we have seen, interestingly, over the last couple of weeks is a pretty dramatic drop in robocalls. And also anecdotally, we've heard from a lot of people that robocalls continue, but not nearly at the rate that they were previously. So, one reason for that might be the economic disruption, and we know that a lot of robocalls originate in India, and with stay-at-home orders in India, maybe that has something to do with this. But we also have seen when we have taken actions against VoIP service providers, we've actually seen measurable drops in robocall volume. So that's an example of how our laws, our existing laws, may be allowing us to respond to the coronavirus, to the coronavirus crisis. We also, though, are assessing whether there might be other statutory changes around the edges, with our authority or investigative authority, things like that where there might be some room for improvement to respond specifically to the COVID issues.
Thanks. Ian, how about on the competition mission?
So for the competition mission, as far as our core antitrust laws, the Clayton Act, the Sherman Act, the FTC Act, and those, what we have seen and the complaints we have gotten that are specific to the COVID crisis are things are kind of run-of-the-mill antitrust, alleged collusion or price fixing, actions, communications between competitors to coordinate responses that are not output enhancing or to actually address the crisis. So I think as far as the antitrust laws go, we have the tools because we're not seeing new actions that we couldn't prosecute under any of the existing laws. We have announced the advisory opinion and the business review letter process in conjunction with our colleagues at the Justice Department to expedite collaborations that would otherwise be potentially problematic, but need to be reviewed. And this is not, again, a change from the process that we would normally go through to analyze proposed collaborations and see whether they raise antitrust issues. The key change is the speed with which we will get back to parties on those proposed collaborations. And that's, after we've received all the information we needed, we would get back to them within 7 days. So again, that's not a change in law or a change in practice. It's just we have expedited the process to address output enhancing or necessary collaborations to address the crisis that's going on right now.
Ian, if I could, let me just follow up on your point about that expedited process for requests for advisory opinions, and the DOJ has a parallel expedited process for business review letters. Can you talk about why you expedited the process, whether there was a need for it? I recall that there was a similar expedited process during Hurricane Katrina, and it's not my sense that there was a lot of use made of it. But do you expect different results here, or is it just having the door open if things come in?
So, as far as the rationale, normally it can take time to do an advisory opinion or a business review letter process. It's just the nature of the investigation. It's not time pressure, and so often other things may take precedence, or we may take time to call large numbers of people within the industry to understand fully the industry. Here, what we're prioritizing is, if you have a pro-competitive collaboration that's been proposed, we will commit to analyzing everything that you have put forward and trying to get a response back to you as quickly as possible so that can actually happen, that collaboration can actually happen. And it's specific really to addressing COVID. It's not, and if you have something that's unrelated to COVID, that's not subject to the expedited treatment. Here it is, and you've seen a lot of manufacturing collaborations, people trying to figure out how to address the supply shortages, how to address interactions on research and development for pharmaceutical products, either to treat the coronavirus or potentially in a vaccine. What we don't want to do is have the risk of potential prosecution inhibit that. And so the purpose of the process is to allow them to propose that at the front end, and then we will get an answer back to them so that they can proceed with the collaborations that are actually going to benefit competition, benefit society.
Ian, if I could just follow up with that with a question really about the substance. Does the coronavirus crisis really change the antitrust rules of the road in any way? Is there really anything that a well-counseled client could not have done in January that would be okay now? We talked about, or you were mentioning, joint ventures to develop new products and things like that, and those would seem to be output enhancing, and if the same rules of the road apply, those are fine. But, I guess I wonder if it's still a problem, for example, an agreement that I'll sell masks in New York and you sell masks in New Jersey. even if there's some argument that that's more efficient distribution of masks, also seems to be an agreement not to compete. Would the antitrust treatment of that kind of agreement be any different?
So the answer is no, and we'll analyze the rationales for it. As I said, the advisory opinion or the business review letter process existed before this crisis, and the standards are not going to be relaxed. We said that in the joint statement. I've made it on a number of blog posts. We're not changing our enforcement priorities or our enforcement standards. So if you want to take advantage of the crisis to try and price fix or fix wage prices, those are the things we will still prosecute. So there's no relaxation of antitrust rules here. The advisory opinion process is just going to be expedited for things that likely would have been cleared anyway.
Thanks, Ian. Andrew, Andrew Smith, makes things confusing with two Andrews. Chairman Simons announced in a recent blog post that BCP would be, in his words, quote, flexible and reasonable about compliance enforcement during this period of challenges with COVID-19. Could you elaborate on what companies may do to demonstrate hardship or the need for relief, and what kinds of types of flexibility BCP might have right now?
Sure. So the chairman's statement served a couple of purposes. One was to say that, look, in this time of need, we're going to continue to vigorously enforce the consumer protection laws where there's consumer injury, and in all aspects, not just COVID related. With respect, though, to the flexibility, we did want to get the word out and also create an email box for companies to contact us. We have gotten some contacts from companies prior to that statement, asking essentially compliance questions. So this is a quick example. We administer a law called the Fair Packaging and Labeling Act, which requires that labels and packages include certain specific information, weights and measures and the like, and also be in English and a variety of other circumstances. So we do have some companies that are trying to import goods that are in high demand, like, for example, toilet paper, and they may not comply with the Fair Packaging and Labeling standards. And so they are asking us whether we would take enforcement action under those circumstances. And so we have gotten questions like that. We also have gotten questions about our enforcement policy with respect to specific legal requirements. And we've been trying to respond to those. I will say that we have not gotten a lot of requests so far to the mailbox that we have set up, but we wanted there to be some sort of a formal process, because this kind of thing shouldn't depend on you knowing the right person to call at the FTC. We wanted companies to have that outlet to the extent that they needed it.
Thanks. One last question for Ian related to the coronavirus crisis, or at least tangentially related to the coronavirus crisis, before we move on to topics of more general interest in the spring meeting panel we would have done if the world didn't look like the way it does today. So Ian, you mentioned with the pre-merger office doing the yeoman work to get electronic filing for HSR set up. I remember years ago, back in 2006, the FTC announced a process for electronic filing, but it was kind of cumbersome, and it's my sense it never really went anywhere. Is electronic filing working out, and do you have enough experience with it now to know that you're comfortable with it, that this is the kind of thing that might allow us to save some trees even after this process ends?
So the transition has actually gone really well. And the pre-merger office deserves the credit on this. They've been able to basically operate because remember, it's not just the pre-merger office at the FTC that has to deal with this, but it's our colleagues at the Justice Department that also have to deal with this. And so being able to get a process set up that quickly, effectively over the course of 4 days was truly remarkable. We've been very surprised and happy with the outcome of that process. We've been able to process basically our normal level of filings as they come in. And so my I think our long-term goal is to have a fully electronic filing system available that is not cumbersome and that does allow filings to continue electronically. The one thing that we would look for as we move forward into potentially doing a fuller electronic filing system is the ability to enter the forms electronically, all the information in the forms, the HSR form itself, because right now what's coming in is not readable. It's just the forms coming in and then the attachments. So we want to be able to basically have a searchable function within the database without us having to basically replicate what's in the forms into our own databases.
Great, thanks. Let me turn now to Andrew Sweeting from the Bureau of Economics, and I will play economist a little bit. Andrew, the draft vertical merger guidelines that the agencies have put out note that the agencies may construct economic models to quantify unilateral effects, but note that, quote, the agencies do not treat merger simulation evidence as conclusive in itself, and they place more weight on whether their merger simulations consistently predict substantial price increases than on the precise prediction of any single simulation. So the DOJ famously, or perhaps infamously, used the Nash bargaining model in AT&T Time Warner. Are there other models beyond Nash bargaining that the Commission would use that you were thinking about in this language from the guidelines?
Sure. So the really big picture point is whether we're looking at vertical mergers or horizontal mergers, we're going to try and use the framework that we think best matches kind of the facts in a particular case. So obviously, if we do think that bargaining between kind of the upstream and the downstream firms is something that happens and determines prices, then the Nash bargaining model is kind of a sensible model to use. If, on the other hand, we thought the downstream firms, use procurement auctions to get their supply, then we would probably adapt and use kind of an auction framework to think about, how the merger would affect competition. Now, I think it's also worth emphasizing that, within the Nash bargaining framework, that covers kind of a wide range of different assumptions that people can use and different ways they can present evidence. So in AT&T Time Warner, while kind of the overarching framework kind of looked like Nash bargaining, the DOJ's expert didn't necessarily, look at kind of the full equilibrium predictions. And, we're very aware that exactly how you set up Nash bargaining models can kind of affect the predictions that you get. And actually, that's a topic of research that some of my new colleagues at the FTC are kind of leading to kind of understand which predictions, what assumptions really matter and how they affect kind of the results that you get.
So just to follow up on that, Nash bargaining seems to me as a non-economist to be really a very simplified model about how prices get set between a supplier and a customer in the real world. And it depends on some big assumptions, like that there is no change in bargaining leverage, or at least difficulty quantifying any change in bargaining leverage post-merger. You mentioned that you've got folks looking at that, but how robust is Nash bargaining? Is there empirical work suggesting that Nash bargaining accurately predicts post-merger price effects?
So it's worth saying that, Nash bargaining as kind of the way to think about vertical relationships is really a pretty new approach, kind of even in the academic literature, looking at vertical mergers. So I think, you should think that the world, our kind of understanding of these models is still really developing. There is some work that's going on in different contexts, trying to understand how well Nash bargains kind of predict what happens, for example, when products become off patent and private labels can enter and that kind of thing. There's actually no published work yet that I'm aware of actually assessing how well these models do at predicting post-merger price changes. But that's actually, the kind of topic that we are trying to address in research. Now, I do want to pick up on one thing you said, actually, which I think kind of misuses the language a little bit and is actually a common point of misunderstanding. So, if you have a Nash bargaining model between kind of an upstream firm and a downstream firm, what the Nash bargaining model predicts is that each firm is basically going to get a deal that reflects kind of its outside option. So what it will get if a deal is not agreed, and then some share of the surplus generated by the deal. So the way that economists think about the effects of a merger is usually in terms of the change of an outside option. So if the outside option of rivals become worse after the merger because they have fewer alternatives, then that will lead to them getting kind of a less of a good deal from the bargain because their outside option has gone down. And usually people would say that that exactly does reflect kind of the change in bargaining leverage created by the merger. On the other hand, the share of the surplus that they get of that created by the deal, that's usually held fixed. And that's actually one of the things which my colleague Charles Tarragin and co-authors are looking at to understand how do the assumptions about that split share affect what you predict about the results of a merger.
Thanks, Andrew. I did concede that I only played an economist on TV, but thanks for that clarification. Heading back to Andrew Smith and some consumer protection questions. Andrew, the FTC is considering proposed changes to the safeguards rule that imposes data security requirements on financial institutions. Can you talk to our listeners who may not be familiar with it, what is the safeguards rule? What are the kinds of changes you're thinking about? And can you tell us why the FTC is thinking about these changes and whether they'll eventually become a floor for reasonable data security, even for non-financial institutions?
Sure. So the safeguards rule, we made the safeguards rule under the Gramm-Leach-Bliley Act. I think the initial rule was finalized in 2002 or 2003. That was actually during my prior stint at the Commission. And at the time that the safeguards rule was made, it was really, I think, groundbreaking. In that it focused on process rather than results. So rather than saying you must use 256-bit encryption, it said you must assess the risks to data in your organization. And it was very risk-based, and it became a model for other risk-based rules that were subsequently made, like the identity theft red flags rule, and a lot of the rules that are being made by the financial regulators. So it was an important rule at the time, but now it's almost 20 years old. And we thought that it was in need of some updating. So keep in mind, this is a rule that applies only to financial institutions. And it's been around for a long time now. And it so far, I don't think that it has necessarily become a floor for what should be good data security in non-financial institutions. But I do think that it provides really useful guidance as to the type of process that you can follow to help to ensure good data security. I would also say, though, that it has become the basis for a lot of our data security orders. So where we have found companies that have fallen short on data security, we have sometimes through order imposed on them safeguards type obligations, such as you must assess the risk to data in your organization, you must develop a written plan to address those risks, you must make sure that your service providers are on board with the plan, you must have designated individual to oversee the plan, that kind of thing. But we thought that safeguards was, perhaps there was some room for improvement, some room for more specificity with respect to safeguards. So we have proposed, I would say, maybe 12 additional, more specific requirements, still process-based. So, for example, we would propose to require financial institutions under the rule to establish access controls, including controls to physical access to data and to facilities. We would propose to require them to inventory data, devices, personnel, and facilities. We would instruct them to establish encryption, not necessarily saying what type of encryption, or if encryption doesn't work or isn't feasible, then have compensating controls. We talk about secure development practices, multi-factor authentication, maintaining audit trails, secure disposal of information, change management procedures, and the like, as well as testing and monitoring. Now, we also talk about governance, which has become a big issue internationally in the privacy world. Sometimes it's phrased as accountability. So you have someone in the organization who owns data security, and you require that person to report to the board, not to the line of business, but to report to the board and provide regular reports and engage the board in the data security planning process. So that's the nature of the new of our proposed requirements. We got a lot of comments, good comments from industry and from consumer advocates and the like, as well as attorneys general. And we have announced a workshop for, I believe it's the 13th of May, that would delve down into some of these issues with more specificity. So these are comments where we felt we could benefit from additional input from industry and others. So that's scheduled for May 13. I think that our plan right now is to do that virtually. We also are hearing from interested parties that date may work a hardship on them. So we're considering, how we can accommodate everybody's needs, but continue apace with this rulemaking. I will also say that the safeguards rule, when it was made in 2002, was somewhat influential with respect to state requirements, and it gave states and other, state departments of financial institutions and others who might be interested in developing their own data security rules. It gave them something to hang their hat on. And it may be that a revision to the safeguards rule would have a similar effect here. It's not preemptive, to be sure, but it does provide, a marker that to which others can respond.
Thanks. Sticking with you, Andrew, turning from data security to privacy, some scholars have expressed concern that enhanced privacy rules like GDPR have enhanced the competitive position or cemented the competitive position of dominant players because startups don't have the resources to ensure compliance. And I suppose you could have the same issue on data security. And in that way, that privacy rules or data security rules could act as a regulatory barrier to entry. Do you think there's merit to those concerns? Is that a concern at the Commission? And does that mean that you'll think about things differently in the US perhaps than GDPR?
Well, it is a concern to the Commission. We did hearings on privacy and data security as a part of the 21st century hearings that were done at the start of Chairman Simon's tenure, and these issues were discussed in those hearings. And there are a lot of different ways that privacy rules might entrench incumbents. So let's say, for example, that you are a startup company and you want to sell camping equipment, and you need to buy a list of potential prospects because you're starting up. You don't have any customers to whom you can market, so you might need to buy a list. So a restriction on the ability to buy a list might make it more difficult for you to begin that business. That's one type of issue that was discussed at the hearings. There also has been a concern that not just that that the costs of compliance might be a barrier to entry, but that there are certain companies that have many more touch points with consumers and are able to obtain the consent that is needed in order to share data, collect, share, use data under GDPR and similar rules. So I do think that we also are concerned about that. Now, with respect to privacy legislation, though, the Commission, I believe all 5 commissioners have said, one, that they're in favor of federal data security legislation, and also that they're in favor of federal privacy legislation, but think that Congress, to the extent that there are important value judgments like, should companies be required to obtain consent before collecting or sharing certain types of data? I think that the commissioners have said that they believe that Congress should make those important value judgments. So to some extent, this issue about entrenching incumbents is a little bit academic because we don't have a privacy law here yet that's very broad that would cover those things. But those are definitely issues that a lot of folks are concerned about. And I think also probably people who are inside the building at the FTC trying to strike those balances.
Thanks, Andrew. Back to Andrew Sweeting and some more questions about the proposed vertical merger guidelines. Andrew, the draft talks about both a relevant market and a related product. Why is that framework for a relevant market and a separate related product used, and why do you think it's useful?
So I think of it as being a potentially useful framework for helping to kind of organize our thoughts about particularly what the anti-competitive effects of a transaction might be. So obviously we know that if we're going to challenge a merger, we're going to need to define a relevant market where we believe that competition is being harmed. On top of that, the related product, which obviously in most cases is going to be the vertically related product, what we need to do is to be clear whether we can explain how the merged firm's control of the supply of some of that related product is going to, cause harm in the relevant product market. So, I think that, just forcing us to say what the related product is, I think is kind of a useful part of the exercise. At the same time, I think a few people suggested that we should be defining kind of two relevant markets. I think that's potentially more cumbersome than would be needed and not necessarily a useful process, because I think it might distract from us focusing on, can we predict what the competitive effects of a transaction are actually going to be?
So when thinking about competitive effects, if there's a model or other evidence that says the price of the related product, let's just call it an input now, is going to go up. Say you've got a model or you've got documents that say, hey, once we've got the control of this input, we're going to raise the price 50%. But if that input is only 1% of the cost of goods in the downstream market, in what we would call the relevant product market, is that 50% increase in the price of an input a concern for efficiency or a concern under the law? Or is the only concern really what happens in the downstream market, and the price increase on something that's 1% of cost of goods just doesn't affect competition, so it's not a problem? How do you think about that issue?
So there's probably kind of a few different things here. So, when you think about a vertical merger, there's typically going to be some incentive to kind of raise the prices of something that you sell to rivals. But at the same time, there's going to be incentives to reduce your prices in order to sell more, and when you internalize kind of double marginalization considerations. So overall, what we focus on as economists is what is going to be the effect on kind of consumers of kind of the downstream products. And if we think on net, kind of the balance of EDM and raising rivals cost incentives are going to make consumers better off, then we would see that as a reason to kind of not challenge the transaction. On the other hand, your question also kind of raised some issues to do with kind of materiality thresholds and how we interpret kind of market shares. So if you just think about market shares, in the example you gave, was the input is just 1% of the costs of goods sold, then that will often kind of indicate that the fact it's only 1%, it could well be that there's readily available substitutes to that input, in which case we'd regard kind of the 50% price increase that you mentioned as probably being kind of fairly unlikely, absent some technological inability to get around that input. The other thing you kind of mentioned, is just kind of the threshold for when we're concerned about an effect. So in general, whether things are 1% or 5%, we're still interested in, whether that's really going to harm consumers downstream. We don't have necessarily a clear percentage threshold in our head. We'll think about both the threshold effect, the percentage effect, the dollar effect, and obviously how confident we are in our predictions before we would recommend to the Commission whether enforcement action should be taken.
Thanks. Ian, back to you with some questions about vertical mergers. The vertical merger guidelines provide for a 20% quasi-safe harbor, and I think the guidelines are pretty clear that it's not really any kind of strict safe harbor, that the agency reserved their right to challenge a transaction if they believe anti-competitive effects are likely, regardless of market shares. But why is the number so low? Just thinking, outside the merger context, you could have a contractual exclusive dealing arrangement, And under Jefferson Parish, there's in essence kind of a safe harbor of about a 35% share of market foreclosure. So should a merger with all of the potential for integration and greater potential for efficiencies be treated more harshly than an exclusive dealing agreement? Or maybe your answer is that, saying that there's a 35% safe harbor for exclusive dealing agreements overstates the existence of a safe harbor. But is there a number that makes a difference, and is 20% too low?
So I will note that many of the commentators on this have complained that the number is so high, and so each vertical merger is going to be a very fact-specific circumstance, and that's the purpose of the guidelines. It's meant to give it guidance that, looking at what we've done before, 20%, if they're at both ends, wouldn't be something we would normally challenge, but there are circumstances that we would bring a case where you have 20% and 20% of overall markets. For instance, where the other competitors are vertically integrated. And so while a 20% market across an entire market is, you have a 20% market share, the share of the contestable market is going to be much higher. And so there are circumstances where we may still challenge a 20% situation. And there are many circumstances where we may not challenge something that is above the 20%. It was meant to give guidance on, and guidance for people to give their own clients guidance on where we see a good break point. But as you note, it is not a safe harbor. It is not a hard and fast rule because we do need to be able to take into account the differences in various market structures.
Ian, one last question for you about vertical mergers. Recognizing that the Commission does have a clear preference for structural relief, is there really any difference between the Commission's thinking on conduct remedies as potentially appropriate in the case of a vertical merger and what Makin Delrahim at DOJ has suggested is really very significant hostility to anything other than structural relief?
And so I think the Commission has a strong preference for structural relief as well. But we don't have any sort of bright line prohibition on conduct relief. We've had a number of mergers where we have accepted conduct relief where we could address the competitive concerns, but also preserve the benefits of the transaction. There's a fairly lengthy statement that was put out in conjunction with the Northrop Orbital transaction that explains our views on conduct versus behavioral remedies, structural remedies. So I think that we are open to conduct restrictions where it would actually be sacrificial of competitive benefits. But overall, the position is a strong preference for structural remedies for any mergers.
Thanks. Andrew Sweeting, a couple more vertical merger questions or guidelines questions for you. The draft guidelines really only address vertical mergers, and of course they're the separate horizontal merger guidelines. How are mergers that are not clearly covered in the horizontal merger guidelines or the new vertical merger guidelines considered at the Commission? Is there any role for enforcement against what I guess folks would call conglomerate mergers based on concerns about post-merger tying or bundling or other kinds of theories about post-merger anti-competitive conduct?
So, my view of the horizontal guidelines and obviously the draft of vertical merger guidelines, which we should all remember are kind of currently in draft form, is that they lay out kind of a set of possible approaches we were making considering kind of a set of issues that commonly arise in mergers. Lots of mergers will bring up both horizontal and vertical questions, and there's no intent with which either set of guidelines I see as trying to be exhaustive about the set of about the set of issues we might consider. So specifically with relation to kind of bundling and tying, right? So usually we see bundling taking place when you think about a merger of products, of firm selling products that are potentially complementary to each other. And obviously there are a set of things in the vertical merger guidelines, are potentially relevant. So the kind of downward price pressures that result from EDM, you can also think are kind of closely related to the incentives that a firm that bundles its products has to reduce the price of the bundle, even if at the same time it could be increasing the prices of the products sold separately. Right. So obviously we'd use the similar principles to try and understand what is the overall competitive effect, to understand, who's going to be buying the bundle, the extent to which they may benefit, and the extent to which there might be some consumers who can only buy kind of the product sold separately, and, how they would be affected. But obviously we know that, just like vertical mergers are often going to be pro-competitive, that bundling is often a pro-competitive strategy. So we'd need kind of strong evidence to the contrary to think about kind of an enforcement action. But if we saw that evidence, then we would recommend that the Commission take an enforcement action.
Thanks. You mentioned EDM, the elimination of double marginalization, and Andrew, the guidelines do seem to treat EDM differently from traditional efficiencies analysis and mergers. What's the reason that the guidelines seem to treat EDM as more certain to be achieved than other efficiencies and mergers?
We obviously do see EDM as being an efficiency. So we also want to have kind of a cognizability, merger-specific kind of standard. On the other hand, I think there are two slight differences from maybe just kind of a production kind of efficiency. So the first one, as I said before, a merging firm is going to want to sell more, ideally at kind of higher prices, right? And obviously eliminating a double margin that exists kind of within the firm is leading it to set a lower final price is going to be something that is going to help the firm to sell more. So as long as we believe that absent the merger, kind of a double margin will exist. So for example, the firms must have some kind of supply relationship, absent the merger that's going to be eliminated, then that's going to be something which is quite natural to assume that the firms will actually do. So as long as we're seeing kind of what the nature of contracts is before the merger or other alternatives that the firms are discussing, then I think it's quite natural for us to assume, yes, the firms, if they're able to eliminate EDM, they would actually choose, if they could eliminate double marginalization, they would actually choose to do so. The other thing which I think we kind of make a distinction about is, you mentioned before kind of Nash bargaining models or other models we might use to kind of calculate competitive effects. Usually we will want to assess kind of the effects of EDM and the effects of raising rivals costs within a common analytical framework. And I think one thing, the way the draft guidelines were written, we're trying to do was to highlight the fact that these incentives interact with each other and that we need a common framework to analyze them. Whereas it could be the case that some other kinds of efficiency we could actually treat somewhat separately.
Thanks very much. Back to Andrew Smith with a couple more consumer protection-oriented questions. Andrew, you've talked about artificial intelligence, spoke publicly about that, and the FTC looked at AI in its recent hearings on the 21st century. Can you talk about the issues that you're thinking about and that you're focusing on in terms of the consumer protection mission and artificial intelligence? And is the FTC working with other government agencies on AI?
Sure. So, artificial intelligence is an interesting thing because some commentators and others treat it as something that's new. And it is to some extent new, and certainly the applications of it are much more powerful than they've been in the past. But we have been dealing with AI probably since the middle of the 1970s or even earlier at the FTC. And so far as, we were the primary regulator for the Fair Credit Reporting Act, which dealt with information that's used to make decisions about consumers, and then also the Equal Credit Opportunity Act, which is all about making decisions about consumers, including automated decisions using an algorithm. And so, the issues that we have traditionally looked at in that context are pretty similar to the issues that other regulators globally have been discussing. So, for example, the OECD put out guidance on consumer protection and artificial intelligence, I think last year about this time. And so the issues that we look at are similar to those in the OECD guidance. So transparency, do consumers understand what's going on with AI? Explainability, so if you make a decision about a consumer based on artificial intelligence or a model or an algorithm, do they understand what that decision is and why you made it? We look at issues, particularly under the Equal Credit Opportunity Act, of fairness and non-discrimination, and we have a lot of experience, as do other U.S. regulators, looking at the discriminatory impacts of automated decision-making tools. We look at the robustness and the soundness, the statistical soundness of both the data that you're using. Is the data that you're using to make your decision clean and accurate? But also, are the models that you're using statistically sound, empirically derived? And then we also look at accountability. So in this context, holding companies accountable for the decisions that they make using artificial intelligence or algorithms, other AI tools, machine learning and the like. But also, regular validation and revalidation of the models that they use to continue to consider whether they continue to be fully predictive and they continue not to discriminate. And some of this involves testing. So what we've seen in the non-credit context are new models that are used, for example, to decide, to make decisions about medical care. And what we have found is that, there are well-meaning institutions who are using models like this, but it's been third parties who have actually come in and validated them and raised the issues with them. And so we would like to see companies doing that type of validation themselves and not waiting for a third party to sort of blow the whistle on them. And this is the kind of expectation that financial regulators in the FTC have imposed on lenders for years, the requirement that they validate and revalidate and ensure that their models remain statistically sound and empirically derived. So I think that, from our perspective, AI is very important, and it's an important, it's now starting to be addressed as a privacy issue. But from our perspective, there is experience out there about how to address AI and how to protect consumers in an AI context.
Thanks, Andrew. Also, a question for you about the recent YouTube settlement. You told MLEX in a recent article, at least if they quoted you correctly, that you thought that the settlement put YouTube on an equal footing with providers of other content in apps and online, and mentioned Section 230. Can you talk about your remarks there and what is the connection, if any, between Section 230 and the YouTube settlement?
Right. Well, so YouTube's not a Section 230 case. So our issue there is the Children's Online Privacy Protection Act, which prohibits the collection of information about kids without, or from kids, without verifiable parental consent. So in the context of that article, what we were talking about was that YouTube hosted content that was child-directed. And the YouTube channel owners frequently had their own organic websites. And there was a situation where the channel owners on their own organic websites could not drop cookies on users and collect information about those users and serve up behavioral advertising to them because that content was child-directed. But on YouTube, which is a general audience platform, there was what folks were arguing is that, well, YouTube's a general audience platform, and it's not under these same COPPA obligations. And we disagreed with that. And our rule states that if you're a general audience platform like YouTube and you have actual knowledge of child-directed content on your site, then you cannot collect data about those users without verifiable parental consent under CAPA. And so essentially we were in a situation where content creators and channel owners could do on YouTube what they could not do on their own organic site, which is a bit of a disconnect. So in the YouTube case, we had really strong evidence of knowledge that YouTube knew that this content was child-directed. So as is outlined in the complaint, there were sales decks and the like that said YouTube is the most popular site for kids 2 to 12, or YouTube is the new Saturday morning television. So we used that evidence to show that YouTube had knowledge of the child-directed content on its site, which made it then subject to CAPA. So that was the Children's Online Privacy Protection Act. So that's the issue in the YouTube case. It's not a Section 230 issue. But I do think that it's an important, the case puts down an important marker, because it is the first time that we've held the general audience platform responsible for collecting data about the users of content on that platform.
Thanks. Let me finish up with a couple of questions for Ian. Ian, the Commission on the Competition Mission really has been exceptionally busy with challenges both on the merger side and the conduct side. Is that just a function of what comes across the transom in terms of mergers that parties are doing or conduct that people engage in and you get a complaint about or discover on your own? Or is there something that the private bar should take from this level of activity at the Commission?
So let me start off by complimenting the Bureau staff, also the staff from the Bureau of Economics and the Commission staff. This has been an exceptionally busy period for us. I went through in preparation for this and tallied it up. So it has been 6 weeks since we started kind of this activity level. In those 16 weeks, the Commission has voted out 7 complaints challenging transactions. Another 2 transactions have abandoned during the investigation without complaints being issued. We have had 3 merger complaints with settlements voted out by the Commission. We have had 1 conduct challenge voted out and is now in federal court. We have another conduct challenge that has been voted out with a settlement. We have issued, as we've been discussing, the vertical merger guidelines. And in total, that adds up to over 16 weeks, 15 public actions by the Commission. So it has been an incredibly busy period, especially if you consider that 2 of the weeks that were covered by that period were Christmas and New Year's. We did not sue anybody during the week of Christmas, but we did bring a complaint the week of New Year's. And the last 3 weeks have been this telework situation with COVID. So as I said, I don't know if it's unprecedented, this level of activity, but it certainly has been something that our staff and both the Bureau of Competition, the Bureau of Economics, and the Commission have risen to this challenge to just take this on, even as we're dealing with the COVID crisis. It has not slowed our activity level. As far as takeaways, I think what people, and we're for some reason having power issues at my house right now. This is the second power outage we've been dealing with, so I'll switch to different lighting. What people should take from this is that we will look at different theories. If you look at the Illumina Pac Bio case, we brought a Section 1 theory and a Section 2 theory claiming potential competition, elimination of potential competition, and monopolization. In the Altria complaint that we just brought yesterday, there is a Section 1 theory and a Section 7 theory. And so we are looking at different levels, different theories, and using the toolboxes that we have. We have in the rent-to-own settlement, we prohibited interlocking directorates, even beyond the scope of Section 8. So we are looking at all of the tools that we have. But as far as the activity level, I think some of it is that we are looking for different cases, some of it is coincidental, where we have just a lot of mergers that came in that, for whatever reason, got cleared out of the boardroom and deserved a challenge from the antitrust authorities.
Well, one last question for you, Ian, about the Commission's use of its toolkit. One of the tools the Commission has is 6B to do studies as opposed to sending out civil investigative demands to gather information. And you're using 6B to look at prior acquisitions by 6 tech clients. And it looks like those 6B orders went to 6 companies. Is there a reason you're using 6B instead of sending civil investigative demands? And then relatedly, as part of that investigation, are you going to be looking at folks other than those the big 6 companies? So, for example, getting the perspective of venture capitalists or startups in the same way that you got multiple perspectives in the PAE study.
So let me differentiate between an investigation where we would issue civil investigative demands and the 6B study. 6B studies are used to understand and study an industry or an issue. You mentioned the PAE study. So they are not for investigative purposes. We do not bring a case out of a 6B study. If there is illegal conduct uncovered during the 6B study, that would result in a separate investigation that would be conducted by the Bureau of Competition. The 6B study itself is being run out of the Office of Policy Planning, obviously in consultation with the other bureaus, but its purpose is to understand the acquisitions that occurred and the background, why they occurred, what happened to the acquisition, acquired either personnel or products following that acquisition. So it's very different than an investigatory civil investigative demand, which says we have reason to believe that anti-competitive conduct occurred here, and we are now investigating that anti-competitive conduct. So it has a different scope and a different intent.
Thanks, Ian. Let me finish by giving each of you, if you needed, an opportunity just to sum up or make any other remarks. But let me give you my thanks and the thanks of the section, both for participating in this in these challenging times and for the work that the Commission is doing under very challenging times. But maybe we'll go to Andrew Smith. Any closing remarks? Anything you want to sum up?
Yeah, actually, I wanted to just mention, which I should have at the top, our efforts to coordinate with other agencies. So we're working on these coronavirus scams, but we're in close coordination with the Federal Communications Commission, the Food and Drug Administration, the DOJ, on a lot of different levels at the DOJ, with state attorneys general, with the U.S. postal inspectors. And so, this is a concerted response by a group of federal agencies to protect consumers from these COVID-related scams. And I would be remiss not to mention the considerable coordination efforts that that the BCP staff is engaged in. But other than that, I think we stand ready. And to protect consumers, and as the nature of the threats change, our response is going to be evolving too.
Thanks, Andrew. Andrew Sweeting, any closing thoughts?
So obviously I talked quite a bit about kind of the draft vertical merger guidelines. So, on behalf of the people of BE, and I'm sure BC as well, I'd also like to thank all the very constructive commenters who have given us a vast amount of feedback. And I know that DOJ and FTC are engaged in kind of discussions about how we can improve the product moving forward, taking a lot of those comments into account.
Thanks. Ian's circumstances are even more challenging than they were at the beginning of the call, but Ian, any closing thoughts?
Yes. So my only closing thoughts are to thank the staff in the Bureau of Competition, the Bureau of Economics across the Commission. We do work with our colleagues in the Bureau of Consumer Protection as well to ensure that our investigations are coordinated, because often we do have parties that are facing investigations from both of us. I think this is, as evidenced by the fact that for whatever reason I've lost power at my house, which is kind of strange. We didn't lose it during the hurricane that hit Richmond a couple of years ago, but apparently we've now lost it. So we are all facing different challenges, and it is really a testament to the dedication of the staff at the Commission, how well we are functioning and how we are still moving complaints, cases, investigations forward. So my closing remarks are just to thank them for their dedication and their work on behalf of competition.
Thank you. Thank you, Ian, Andrew, and on my own behalf and behalf of the section. So thank you. And with that, we'll end it and pitch it back to John Roberti. Thanks.
Thank you, Jonathan. Shylah, really great discussion. I want to come back to you and ask you, what are some of your takeaways from today's panel?
Well, certainly COVID-19 and its impact is a topic of conversation, I think, for everyone, and is having an impact on everyone, and certainly is having an impact on the agency as well. Not only in terms of timeliness or efficiency, but also in terms of their focus. As you heard, fraudsters are finding new innovative ways to implement scams, and the agency is looking ahead to kind of the issues down the road, financial impacts, financial distress issues that they may need to deal with, and start planning through how they'll address those. But as you also heard, the agency has really rallied to find effective ways to return to as nearly as close to business as usual as one would hope. The electronic filings have been set up, early termination process has been restored, and cases are moving forward. And to the extent that the spirits of the Commission are strong, they are as well as they can be in this situation.
I found it to be very helpful to hear the commitment to keep things going despite this emergency, and frankly, in the middle of or towards the end of the program, one of the panelists loses electricity, and that is just one of the things that we are all confronted with. And again, I think the agencies are just going to probably just fight through this. Shylah, any other takeaways from today's program?
A couple of other things. They discussed the safeguards rule. So the safeguards rule was imposed, or it did impose data security requirements on financial institutions. It was implemented in about 2003, so it's a bit old. And the FTC has represented that it's going to be undertaking some updates to that rule. The way that they look at it is it's not so much as a floor, but a measure to provide useful guidance to data security across multiple industries, not just financial institutions. But the updating is really to provide more specificity. So there's about 12 proposed specific requirements, more specific requirements that they have proposed, both process-based and governance-based. They mentioned that they've gotten some really good feedback from the industry, really good comments, and that they're going to be having a virtual kind of town hall or workshop, I think it was May 13, to follow up on those comments to provide some additional guidance before they finalize that safeguard rule.
Great. And Shylah, any last takeaways from today's program?
Overall, that it is very much the Commission or the agency is really committed to getting things done. Understands that they need to be flexible. Are also appreciative of outside counsel being flexible with them. But they're focused on this, on their work and moving things forward. And I think this session is a testament to that as well. And as you mentioned, the power going off in the middle of the session. They're very busy these days trying to keep things running as usual, which I think takes us all more time and effort than normal. And they've taken their time out of their day to speak with us today and provide us with this helpful guidance. So really appreciate their efforts.
Now, Shylah, let's shift gears for a second. You're the chair of the Federal Civil Enforcement Committee. Tell us what that committee's up to. Maybe tell us how young lawyers can get involved.
So, email, call, FaceTime, whatever you want to do. We love new members, returning members. Please contact us. So the Federal Civil Enforcement Committee monitors developments in civil antitrust enforcement and consumer protection policy and actions at the DOJ and the FTC. Paying particular attention to kind of agency rules, practice and procedure, updates, enforcement efforts. And some of the activities that we're involved in is we publish bi-weekly updates from the FTC and the DOJ. So it's a great kind of one-stop shop to get your finger on the pulse of what's been going on at both of the agencies. We publish interviews, in-depth interviews with various DOJ or FTC officials. And we host informative brown bags on recent developments and kind of upcoming issues and trends that we're spotting at the agency.
Great. Shylah, thank you. Thank you for coming today. And I should have mentioned at the beginning, Shylah was the session chair of the panel, which means she was the one who really organized it. So Shylah, thank you for that, and thank you for your comments today. I also want to thank you, Jonathan GLEKLEN, all the panelists, all the agency bureau directors for making time today for a really helpful discussion. And most importantly, I want to thank you, those who are watching us, our members. Thanks for giving us a chance on this virtual spring meeting. We hope to see you next time. Until then, be safe and be well.